All right, this video focuses on how a case actually reaches the Supreme Court. The rest of our focus is going to be on like how the Supreme Court actually does its job. So, how does a case get to the Supreme Court? So, here's our current Supreme Court, like 9 justices. Like, how does a case actually get before like these 9 individuals? We talked previously about the difference between state and like federal courts. It doesn't matter if you're on the state side or you're on the federal side. It is possible to reach the Supreme Court from either like beginning in a state court or beginning in a federal court. So that's important to understand. It's also important to understand that it's not your right as an American citizen to have your case heard before the Supreme Court. You definitely have a right to appeal, and there are appeal options on both sides, but they decide what cases they want to hear. Like you can't force a case into the Supreme Court. They have complete control over what cases they actually want to hear. All right, so how does the case actually get there? Well, there are a couple different ways. So we talked about jurisdiction before, and that's like who gets to hear the case, right? So the Supreme Court is a rare type of court that has both original and like appellate jurisdiction. So original jurisdiction means, going back to the previous picture, that the case actually starts in the Supreme Court and avoids like all these other like lower levels, right? That's called original jurisdiction. It's really rare that the Supreme Court would claim original jurisdiction and want to hear the case first. If there was a case involving a dispute between two states or a case involving a dispute with like some sort of foreign government official, like they might take the case, but that's really rare, right? Usually, the Supreme Court issues or exercises what they call appellate jurisdiction, and that simply means that like the case goes through the other levels first. Like a bunch of courts have already heard the case, and then the Supreme Court hears it after a bunch of other courts have heard it. Usually, disputes over constitutional issues and things like that will start at lower levels and then eventually work their way up to the Supreme Court. Right, so it's much more common for the Supreme Court to hear a case on appeal, meaning other courts have already ruled and they get final say, as opposed to them having like first say with original jurisdiction. There are probably about 8,000 cases each year that are appealed to the Supreme Court. And in a busy year, they might only hear 70. So it's like the rare case that actually makes it all the way to the Supreme Court. And again, it's not your right as a citizen to have your case go there. So each Supreme Court justice has 2 to 3 clerks that help them. Think of a clerk as an intern, but like these interns are like usually law school graduates from like the most prestigious law schools throughout like the country, Harvard, Yale, Princeton, places like that, right? And they like intern for judges, usually a year at a time. And it's usually the clerks that are going through these 8,000 cases. And like they know that their judges that they work for are interested in certain cases, and they'll find a case like related to something they're interested in. They'll summarize the case, then like explain it to the judge that they work for, right? And then a couple times a year, like the 9 judges will get together and they'll conference, and they'll actually make arguments to each other over like what cases of the 8,000 that they should accept and they should hear over the course of the next couple months, right? And then when they're in conference arguing about what cases they should hear, there's something called the rule of four, right? Where 4 of the 9 judges need to agree to like accept a case. So, if you're a judge and you're saying like, hey, I think we should take like this case, it's really interesting, it's important for us to take the case, you just need then beyond you 3 other judges to vote to accept the case. And then if you do accept the case, and again, in total, 4 of the 9 judges agree to hear the case, then the Supreme Court will issue what's called a writ of certiorari, which is a fancy like legal sort of like document the Supreme Court will release that will force like the lower courts that heard the case to send up all the relevant records to that case to the Supreme Court. And for the public, this is the first sign that the Supreme Court has agreed to hear a case when they issue this writ of certiorari. So again, the odds of a case getting to the Supreme Court are slim to none. Again, in a really busy year, maybe 70 of 8,000 cases, and the clerks have a pretty important role in like sort of like screening through all these cases and then presenting it to their judge, then has to convince a couple other judges to agree with them.